New York City has once again made changes to its Earned Safe and Sick Time Act. Effective March 20th, 2024, employees will have a private right of action to directly sue their employers for alleged violations of the Act. To recap, in 2014, New York City became one of the first cities in the United States to require 40 hours of paid sick leave each year. In 2020, New York State enacted a statewide paid sick leave law, requiring large employers to provide 56 hours of paid leave annually. On September 23, 2020, the New York City Council amended its law to align with the new state law, and years later, on September 15, 2023, the New York City Department of Consumer and Worker Protection released final amendments to the New York City Earned Safe and Sick Time Act rules, codifying the 2020 amendments to, among other things, make clear that large employer status is determined by an employer's total U.S. workforce, not just New York City employees. Bringing us to the most recent amendments, under which, beginning March 20th, 2024, employees will now have 2 years from the date they first knew or should have known about an alleged violation of the Act to file a lawsuit. Employees will also continue to have the right to file an administrative complaint with the New York City Department of Consumer and Worker Protection, as they did previously. Such an administrative complaint, however, is not a prerequisite to filing a lawsuit. Before this most recent amendment, employees could recover civil penalties and lost wages and benefits under the Act. But now, employees may also recover compensatory damages and other injunctive and declaratory relief, including attorney's fees and costs. Employers should also be aware of recent news regarding the Minnesota Earned Sick and Safe Time Law. The law, which provides for up to 48 hours of paid leave each year, went into effect on January 1, 2024, and is already facing potential amendment. The proposed changes, currently being considered by the Minnesota legislature, would require employers to pay earned sick and safe time at the employee's regular rate of pay, presumably referring to the FLSA calculation, to eliminate confusion around the current bill text. The amendments would also provide for increased penalties and a presumption of violation for insufficient record keeping. For more information, take a look at our previous client alerts on this topic. As always, if you have any questions, please reach out to a member of our team.